I think we're now ready to resume. Mr. Smith.
Thank you very much, my lord. Perhaps I may begin just by picking up some of the points left outstanding from this morning. First of all, with my Lord Sale's question about the figures, and we do have some information on that. If your lordships go to page E642, the electronic bundle, there is a table on that page. This, I should say, forms part of the joint memorandum of the quantum experts. And your lordships will see the table on page 642 deals with what are referred to as the net investments at 6 different relevant redemption dates. The relevant redemption dates you will see back on page 640, and they are 6 hypothetical dates that run from October 2002 through to November 2008. And as you'll see from page 642, how the table essentially works is to show the net investments at the relevant redemption date. So that is essentially cash gone in, net of cash taken out, and then net investments after the relevant redemption date. So that gives you an idea of cash flows. And then there's also another table on the next page. Page 6.
I'm sorry to interrupt, but when it's talking about investments, is that the money that had cash put in?
That's right. So it's effectively, this is on a net cash basis. So net investments as at the relevant redemption date is cash that's gone in, net of cash taken out, because plainly there's cash coming out in terms of redemptions as well.
Yeah, and is this specific to Primeo?
Yes, this is Primeo, yes. So that deals with that table on page 642 effectively is a cash accounting analysis. Then there's also another table on page 643 in paragraph 2.11, and this deals with what's called withdrawal value. And the difference between this table and the previous one is that the first row of figures shows the withdrawal value as per the statements of account produced by Bilmis. But as you'll see, that the second row is the same, because that's again net investments after the relevant redemption date. So I hope that gives your lordships some idea of the figures. My lord, the second point I was going to deal with was my Lord Reed's question about various proceedings which have been commenced by Herald and Alpha. And the easiest way, I think, to pick that up is probably by reference to the agreed statement of facts at page 778 of the bundle. And this deals in turn with the position in relation to Herald and then in relation to Alpha.
Sorry, page again, please.
778.
Thank you.
So far as Herald is concerned, the narrative begins on paragraph 16, and that refers to the main set of proceedings commenced by Herald against the second respondent in Luxembourg. Those were commenced in April 2009, and you'll see they essentially involve restitution claims, or did involve restitution claims and contractual breach of duty claims. And then on paragraph 17, you'll see the claim for restitution of the security was dismissed. and then there is an appeal, which is still ongoing, notwithstanding that the first instance decision was March 2013. And then what happened much more recently is against the what appears to be an expiry of a limitation period in Luxembourg.
Just to understand this, when it's talking about in paragraph 16, the restitution of securities deposited presumably by Herald with R2, is that the fictitious security?
Yes.
Right. Okay. So in fact, there are no securities, and not surprising if a restitutionary claim is dismissed.
Yes, that may explain paragraph 17. Your lordship's right. Yes. Yeah, indeed, first sentence of paragraph 17, you can see the claim for restitution of securities has been dismissed, although apparently being appealed, and the appeal's ongoing. And then from paragraphs 18 and 19, there were essentially two new sets of proceedings, which appear to have been prompted by the expiry of a limitation period, being 10 years after Mr. Madoff's arrest, which was December 2008. And those are further proceedings which I think it's fair to say don't appear to have gone anywhere, at least yet. And then paragraph 20, as I explained earlier, there isn't any contractual relationship or any claim against the first respondent. So that's Herald. And then so far as Alpha is concerned, paragraph 21, just to note, the final sentence makes the point that Alpha doesn't in fact have a contract with either R1 or R2. But then paragraph 22, nonetheless, Alpha commenced proceedings against the second respondent in Luxembourg. And then it appears to have applied itself for a suspension of the proceedings, and the proceedings have been suspended. And then again, paragraph 23, there's similar to Herald, it looks like a further claim was issued just against the expiry of the limitation period. And then just to note, footnote 3, there were other claims, some cross claims which were dismissed, and then a writ in relation to a claim in Bermuda which has never been served.
In paragraph 18, the restitution of $520 million. I suppose Herald may well have been receiving, taking in money from third parties who are wanting to invest in the Madoff fund, but that cash won't have included any money paid by Primeo, will it?
That's correct. Yeah. So that cash had already been paid to Bilmis prior to Primeo making its investment in Herald.
Yeah.
So that wasn't cash that was transferred by the second respondent to Bilmis on or without Herald's instructions.
Yeah.
So that deals with the position in relation to the proceeding. Now, your lordship then asked me in relation to the merits test, well, why isn't the answer just to stay the present proceedings until we get the answer in Luxembourg? And there's a number of points we make in relation to that. The first is a point about burden, and we submit the burden is on the respondents to establish that our claims ought to be shut out by the reflective loss principle. They didn't in fact apply to stay the proceedings at any point, and the proceedings have proceeded to lengthy trial in the Cayman Islands. And in our submission, it's too late now for, in effect, the respondents to say the claim ought to be stayed. I'm sorry, I see there's a message that Lord Hodge is not present.
Yes, we had better wait to see if he reappears.
I am present, but my camera seems to be freezing up.
Fine, we can see you again now.
So as I was submitting, we submit the burden is on the respondents to establish that our claims are shut out by the reflective loss principle. They didn't in fact apply for a stay at any stage. The proceedings have proceeded through to trial, and in those circumstances the burden is on the respondents to make good at trial that our claims are effectively excluded by the principle. And we suggest it's too late for them now to say that the proceedings simply ought to be stayed pending the outcome in Luxembourg. The second point is a more factual or evidential point, which is simply that there is no evidence as to when the proceedings in Luxembourg may be concluded. If the respondents were applying for a stay, that's the sort of evidence they'd have to put forward. From the material we do have, one can, I think, make the point that there is at lowest a question mark about when the proceedings in Luxembourg will be concluded. If one looks at the chronology, one has a claim that was commenced in April 2009. So now, almost 12 years ago, perhaps slightly over 12 years ago now, and all that appears to have happened is that there was a first instance decision dismissing part of it and an appeal against that first instance decision still pending. If the remainder of the proceedings continues at the pace the proceedings appear to have continued so far, one's looking at a very considerable time into the future. And in our submission, that would be unfair and unjust for the proceedings to be delayed for that length of time. But in any case, what the response haven't done is put forward any evidence as to the timescale in which they might be resolved. So in our submission, having got to this position, it is incumbent on the respondents to establish at trial that our claim is actually excluded by operation of the reflective loss principle. And in order to do that, they have to establish that the merits of the company's claim satisfy the merits test, whatever it is. Now, turning again to the question of what the merits test ought to be, in our submission, there's two key factors that the court should bear in mind in this context. The first is that the prudential rule is an exclusionary rule, which may operate to bar completely what is otherwise an entirely good claim. It's been described as a blunt instrument. Clearly, it has the potential to have that effect. It certainly has a far-reaching effect. And secondly, that even where the rule doesn't apply, the principles governing the assessment of damages, proper calculation of compensation, and preventing double recovery will still be applicable. So one's not in a situation where one concludes that the rule doesn't apply, issues of double recovery and so on and so forth aren't capable of being dealt with. Now, in our submission, it follows from that there is what one might describe as an asymmetry of prejudice. The prejudice from applying the rule in circumstances where the company turns out, in fact, to have a bad claim is much greater in our submission than the prejudice of not applying the rule in circumstances where the company, in fact, turns out to have a good claim. So if one gets it wrong and excludes the shareholder's claim because of a mistaken assessment of the merits of the company's claim, the prejudice is much greater than if one makes the error in the other direction and mistakenly allows the shareholders' claim to proceed. And the reason for that, what I've described as that asymmetry of prejudice, is that in the former case, there is prejudice because the shareholder who may have had a good claim will make no recovery and the wrongdoer will get off scot-free. But in the latter case, the prejudice is limited because the rules governing double recovery and the assessment of damages will in any case prevent the shareholder from making a double recovery and the wrongdoer from having to pay out twice. So that's why we say there's what I've described as an asymmetry of prejudice. The downside of getting it wrong and erring on the side of excluding the shareholder's claim is much worse than the downside of getting it wrong by allowing the shareholder's claim, because in the latter scenario, you've always got the rules governing assessment of damages, which in effect operate as a safety net and will allow double recovery and those sort of issues to be dealt with. Now, if that analysis is right, and we submit that it is, it means that one should only apply the rule in clear-cut cases. In other words, one should only apply it where one is confident that the company does in fact have a good claim, so that one isn't in a situation of dismissing the shareholder's claim, which may be good, by reference to a claim of the company which may be doubtful or bad. So we submit that any doubt, including any doubt about the merits of the company's claim against the wrongdoer, should be resolved in favour of the shareholder rather than in favour of the alleged wrongdoer. And you can test that or illustrate it perhaps by reference to the facts of the present case. Subject to the prudential rule, Primeo has valid claims as a matter of Cayman law against both respondents. They've been upheld as to duty, breach, in large part as to causation and limitation. So we have good legal claims in large part as a matter of Cayman law. Why, one asks, should those claims be entirely barred simply because Herald has brought claims in Luxembourg against one of the respondents, which were issued in 2009, which don't appear to be anywhere near trial, and the merits of which the evidence puts no higher than a real prospect of success? Why is it that Primeo's good Cayman claim should be struck out because a Luxembourg claim has been issued and effectively sort of creeps over the threshold of someone being able to say it's got a real prospect of success? We respectfully struggle to see the merit of that, and we suggest that sort of approach is to favour the wrongdoer or the alleged wrongdoer, when the benefit of the doubt, if there is any doubt, ought to be given to the claimant. So in our submission, unless it can be said with confidence that the company's claim is better than or of equivalent merit to the shareholder's claim, then there's no sufficient basis for the rule to be applied to exclude the shareholder's claim. Both claims should proceed, and the usual rules governing assessment of damages can be applied in order to avoid double recovery and avoid double payment. Essentially, there is no particular difficulty because one's in exactly the territory of those cases which the Supreme Court discussed in Marex, where one does have claims brought by different parties, possibly against the same person for the same loss, and there's various techniques the law has available to deal with that. In our case, it's going to be through the assessment of damages, and Primeo giving credit for the value of its shares in Herald. So we respectfully submit that in circumstances such as the present, where the company's claim is yet to come to trial, but the defendant wrongdoer is seeking to exclude the shareholder's claim in reliance on the prudential rule, and where the shareholder otherwise has a good claim against the wrongdoer, then it's for the defendant to show that the company's claim is more likely to succeed at trial than not. And the defendant should be required to show that in order to get rid of the shareholder's otherwise good claim against it. Now, related to that, there is a further point which we would make, which is that in our submission, the prudential rule shouldn't be allowed to be used as a tool to enable a wrongdoer to escape liability to both the company and the shareholder. And in particular, one has to ask oneself, why is it that a defendant wrongdoer at the same time ought to be able to say to one court that the shareholder's claim should be barred because of the company's claim, but at the same time say to another court in another jurisdiction that the company's claim is bad and ought to be dismissed? Because, of course, the reality of the position here is that although the respondents want to say to the Cayman courts that the claim by Herald and the claim by Alpha is a claim of merit, so that Primeo's claim ought to be struck out. But at the same time, in Luxembourg, they're actively defending those claims, and I don't think it's I don't think it's an unreasonable inference to say that they won't be saying to the Luxembourg court that these claims are full of merit and ought to be allowed to succeed. Of course, they're saying exactly the opposite to the Luxembourg court. One would expect them to say that because they're defending those proceedings. So the mischief to which the test adopted by the Court of Appeal gives rise is that it effectively allows the possibility of a wrongdoer to say to one court, well, you ought to get rid of the shareholders' claim because the company's claim has a real prospect of success, but then at the same time say to another court, well, the company's claim actually is a bad one and ought to be dismissed. And in our submission, the facilitation of that sort of approach, which is ultimately designed to enable a wrongdoer to escape liability completely, goes well beyond any mischief which the prudential rule was designed to deal with. And we respectfully submit that isn't a proper function of the prudential rule to enable an alleged wrongdoer to take those sort of inconsistent positions with the ultimate aim of evading any liability whatsoever. And the answer to deal with that mischief is to say that the prudential rule can only be invoked to knock out the shareholder's claim where the court is satisfied that the company's claim is a good one. So, my lord, that is what we would say about the merits test point, and ultimately we say that the Court of Appeal was wrong on the merits test point, and if the correct test is applied, the respondents haven't met the threshold of demonstrating that the relevant claims in this case meet that threshold. The final topic then concerns Primeo's indirect investments. So this is that part of Primeo's investments which were invested in Herald and Alpha. As I say, this is irrelevant to the strict liability claim, which only relates to the direct investments. So far as the breach of duty claim is concerned, then we accept that this part of Primeo's loss would be suffered by it in its capacity as a shareholder in Herald and Alpha, and it would, in principle, take the form of a diminution in value of that shareholding. And that's the fundamental distinction between the direct and indirect investments. However, the points made above about the nature of the claim which the company must have against the wrongdoer apply equally here to the indirect investments. First of all, there is no basis for barring the claim against the first respondent because neither Herald nor Alpha have a claim against the first respondent. Second, there is no basis for being able to rely on any claims of Alpha as a basis for applying the prudential rule because Alpha wasn't in a contractual relationship with either the first respondent or the second respondent. And thirdly, in any event, the respondents have not established that either Herald or Alpha have claims which are likely to succeed applying the correct merits test. So for all those reasons, we submit that the claims, insofar as they relate to indirect investments, aren't barred either, although obviously the reasoning differs when compared with the direct investments. My Lord, those are our submissions. I think I was due to go until 2:30, so I've shaved 4 minutes off my allotted time. I don't know if your lordships have any questions for me.
Not at this stage, it appears.
Well, thank you very much. In that case, I will go on to mute and hand over to my learned friend.
Well, thank you, Mr. Smith. Mr. Gillett.
My Lords, if I could start by outlining the order I will deal with matters in, and according to the best laid plans of mice and men, give an estimate of how long I anticipate spending on each issue. So my learned friend had 6 points that he made, and the first 3 related to what's been called the timing argument. And I'll deal with that argument first. So that is essentially the argument that Primeo's cause of action arose before May 2007, when it was not a substantial shareholder in Herald, and it suffered loss, and which was not referable to diminution in value of shares, and therefore is not within the scope of the rule. So that's the nub of his argument. And I anticipate spending about 2.5 hours on that. The second issue is what we've termed the R1 alpha issue. Using a shorthand, that's the common wrongdoer point, and the question of whether it makes a critical difference that Primeo had no direct contractual relationship, even though there were pass-through claims. The third issue is the matter my learned friend has been dealing with, the merits test. Likely to succeed or reasonable prospects of success. And then the final issue, which my learned friend was just dealing with, is the indirect investments point. I'm not going to spend any time on that because on analysis, it doesn't raise any points that are different from the R1 alpha merits point. So, my lords, could I start with the timing issue? And what I'd like to start by doing is to define the issue by way of an example, and then outline the key facts, and then give you an overview of our position. I'll then move on to the reference point, which the critical point for timing. At what point do you apply the test? And I think my learned friend indicated that in one sense is the crux issue. So let me start, if I may, just by giving an example, which we think fairly encapsulates the issue. Let's say that P has a cash box. I knew you'd be delighted to have a reference to a cash box or a safe box, but in this cash box, we have a £100 bond. Now, negligently, the solicitor fails to tell P that the bond must be redeemed by December 2008, otherwise it will expire with no value. If the solicitor had told him that, P would have redeemed the bond then and there. P then enters into a subscription agreement with H Limited. He transfers the cash box with its contents to H in return for £100 of shares in H. The solicitor also acts for H Limited, and he negligently fails to advise H that the bond must be redeemed by December 2008 or it will expire without value. December 2008 comes and goes without the bond being redeemed, and it expires without value. In that situation, can P sue, so the personal claimant, the shareholder, can he sue the negligent solicitor for £100, or is his claim barred by Prudential? Now, Primeo says that P can sue. It puts its arguments in various different ways, and ultimately they're all variations on the same theme. Primeo says the rule doesn't apply because P's claim, Primeo's claim, is not brought in its capacity as a shareholder in H, or because Primeo was not a shareholder in H Herald at the time the cause of action accrued, or because when Primeo first suffered loss, it wasn't a shareholder. In consequence of all of that, they say it's not a claim for diminution in share value. We say in the example that P's claim is barred by the rule in Prudential as explained in Marex. And tested at the relevant time, namely when the claim is brought, P. Primeo was a shareholder in H. Also, his claim is for a loss which will be made good through restoration of value in his shares, were H's claim against the common wrongdoer to succeed. So we say, both in the cash box example that we've given and on the facts of this case, P. Primeo's claim is barred. Now, my learned friend might suggest that the example I've given is not representative because Primeo suffered loss before the Herald transfer. In our example, P also suffered loss because he would have redeemed. But in any event, we say that makes no difference because that loss ceased to be separate and distinct in consequence of the Herald transfer, and the applicability of the rule is determined by the facts and circumstances existing at the time the claim is brought. So can I move now just very quickly to outline what we say are really the 9 key facts. First, Primeo's cause of action against the respondents under the 1996 custody agreement and administration agreements regarding the direct Blimis investments accrued pre-May 2007. Second, there's an unresolved issue because this is subject to a second appeal about when loss was first suffered. But we accept, for the purposes of this appeal, that the Privy Council should proceed on the basis that the Court of Appeal found that loss was first suffered pre-May 2007. But that finding also has to be viewed in the light of the fact that it was Primeo's own case that it could have redeemed for full value at any time prior to May 2008 all of its investments. It's a point that I'll come back to, but it's a terribly important point to understand. All of Primeo's breach of duty case worked in this way. If only you, the respondents, had told us what you should have done, we would have withdrawn all of our investments before the nature of the fraud was disclosed. And that founds the basis of their damages claim, the amount of money they say they would have withdrawn. So I'll come back to that just in a moment, but it's an important point. The third factual proposition is that on the 2nd of May 2007, Primeo became a substantial shareholder in Herald when it transferred the pre-May 2007 assets under management, in respect of which it now claims in Cayman. So those are the direct Plymouth investments. It exchanged those very assets through an in-specie subscription for shares in Herald. So that's the Herald transfer. Important to emphasize, the very assets in respect of which Primeo claims in the Cayman proceedings are the very assets transferred under the Herald transfer. I refer to them as assets. In actual fact, they were choses in action, the right to claim payment of cash or the delivery of equivalent securities. So there were no proprietary rights as against Bilmis, just contractual rights. But I'll refer to that as an asset. The fourth factual point is that Madoff's fraud was disclosed or revealed on the 10th of December 2008. Herald suspended the calculation of its NAV and subsequently entered liquidation proceedings. 5. In 2009, Herald issued claims against R2, including for damages in respect of the direct Bilmis investments transferred to Herald under the Herald transfer. Your Lordship's looking at the statement of facts was focusing on the rectification claim. That's not the important point. The important point is that Herald in Luxembourg is claiming damages of $5.6 billion. The sixth factual point is that when in 2013 Primeo issued its claim against the respondents in Cayman, as regards the loss suffered on the direct Bilmis investments, Primeo remained a substantial shareholder in Herald. At that stage, it held 31% Herald's issued share capital. So it's probably the biggest shareholder in Herald. Seventh point, were Herald's claims against the respondents in Luxembourg to succeed, Primeo would be made good for the damages claimed in the Cayman proceedings through restoration of value in its shares in Herald. Now, I was originally going to say that that's not disputed. That, in reality, it's not disputed, and let me just run through that. It was not disputed before the Court of Appeal that the Herald claim, if it succeeded, would make good Primeo's loss. And even this morning, and I think this will appear from page 42 in the transcript, that my learned friend was initially inclined to accept that if the Herald claim succeeded, Primeo's claim would be made good. And as I've outlined to you, that is the reality of the situation. because Primeo's case on its breach claim was that if the respondents had acted in accordance with their duties, Primeo would then and there have withdrawn its investments and received cash. And that was the basis upon which they pursued their damages claim. And if I can just, in one sense, make that good, just by looking at MS page 640, which was the joint experts report on quantum that my learned friend just took you to. So at the bottom of the page, on page 640, my learned friend was explaining that those were the relevant redemption dates. So those were the dates by which Primeo was claiming damages. And as you can see from the sixth one, Primeo's case was that they could have redeemed all of their investments on the 1st of November 2008. And then if I can ask you to look at the table, MS 642, you can see that on a net cash basis, they were saying that their loss by not being able to withdraw was 310 million. And then if you go on to page 643, this is looking at their damages claim on a withdrawal basis. They're saying that if only you had told us on the 1st of November 2008, we would have redeemed from Bilmus 695 million. And that's how Primeo put its case. And that is exactly how Herald is putting its case in Luxembourg as well. So in a sense, both of the claims are premised on looking at what is the essential nature of a Ponzi scheme. And in that context, could I just ask your lordships to look at the MS 1554, and this is in the Privy Council's decision in Pearson and Primeo, but it's just the quote at paragraph 8 from Lord Sumption in Fairfield Century, which is explaining the nature of the Ponzi scheme. It's inherent in a Ponzi scheme that those who withdraw their funds before the scheme collapses escapes without loss and quite possibly with substantial fictitious profits. The loss falls entirely on those investors whose funds are still invested when the money runs out and the scheme fails. And that's why both Primeo and Herald are saying that if only you had performed your duties, we would have recovered all of our cash and indeed fictitious profits. So coming to the point that my Lord Reed made, asking, could Herald ever have recovered for fictitious profits? Yes, their case is they could have done if we had complied with our duties, notified them, so they withdrew all of their investments before the scheme collapsed. So that is why we say that it was not disputed, and in truth cannot be disputed, that if Herald's claim in Luxembourg were to succeed, Primeo's claim would be made good. And in fact, just at this point, if I can just make one other point, although the Cashbox example in Prudential was maligned for being unrealistic, in actual fact, Herald is like the company in that example, because Herald's only assets were its rights in connection with the managed accounts at Bilmus. the value of its shares was directly correlated to the value of those rights, and they determined the NAV of its shares. So the NAV of one dictated the NAV of the other. So in that sense, as I say, Herald was like the company in the cash box example. The eighth point that we make is that Primeo.
Yes, just before we leave that, I wonder how exact that analogy is, because the shows in action, which is part in the cash box in your example, doesn't really have a true value, or it has a true value which is a small proportion of what it purports to be its base value. So it's not like holding just £1 in the cash box. People think it's £1, but in fact it's, I don't know, 1 penny or something like that. Does that affect your analogy?
No, it doesn't. The only point that I was trying to make is that there is a direct correspondence, a one-to-one correspondence between the value of the company's assets and the value of the shares. Because the value of the share is directly dependent upon the NAV of the direct business investments. So that's the, and it's a point that I'll expand upon. What I was going to say is that this case is a case where there is a direct one-to-one correspondence between the loss suffered to the company assets and the reduction in value of shares. So that's the eighth point that I was going to cover.
Can I just pursue a related point before we leave this? Herald, as I understand it, is a perfectly genuine fund, which is taking in investments, taking in cash from customers, and investing it in Madoff's fund. And so it has invested the money in return for some sort of investment that are supposedly held by limits. And if it's been negligently advised, then in principle it's entitled to recover its loss, and its loss would certainly include the amount that it had invested and the well, what should have been the value of its investments, including profits that it should have earned on those investments, which is what Lord Sumption's accepting here. I've got no difficulty with that. But so far as Primeo is concerned, Herald doesn't take any money from Primeo and invest it.
No.
What it takes from Primeo is an account which contains fictitious entries. It's as if it's being given a cash box and told there are millions of pounds worth of assets inside this box, but in fact the box is empty. And what I'm struggling at the moment to see is how Herald could recover in respect of the contents of the box what Primeo could recover by way of the investments which it believed it had paid for and the return that it ought to have received on those investments.
My lord, I'm going to come to that point within 2 minutes.
Oh, fine.
Because I think it's terribly important that the court understands what has been the effect of the Herald transfer in financial terms. So I will come to that within 2 minutes. The eighth point I was going to make is that Primeo do not allege that they suffered any loss which would not be made good through restoration of value of shares in Herald. So this is a case where, in the terminology of my Lord Reed, paragraph 33 and 80 of Merrick's, the only remedy the court would need to provide to achieve its remedial objective would be an award of damages to Herald. And also, if I have understood my Lord Sale's judgment correctly, paragraphs 148, 164 and 194, that seems to accept the application of the prudential reflective loss principle, where there is no difference between the loss claimed by the company and the shareholder. And so that falls into this situation. And so to just make the point good, for example, at paragraph 164, which we have at MS 1057, Lord Sales says, in my opinion, for the reasons set out above, the unity of interest point and the proper plaintiff point do not support the reflective loss principle, insofar as it is sought to be applied in relation to a different loss suffered by a shareholder in relation to which he has his own cause of action. So I understand that to be indicating that where there is a direct one-to-one correspondence between the company's loss and the shareholder loss, and no other different loss is suffered, Lord Sales accepts the application of the prudential principle. Ninth, and although this is more by way of submission, there can be no doubt, we would submit, that Primeo's claim competes with that of Herald's. And it's noticeable, we would suggest, that in my learned friend's submission, despite the fact that competition between claims lies at the heart of the court's decision in Merrick's, there was no discussion by my learned friend as regards how Primeo's claim competes with that of Herald's. And I'll come back to my Lord Reed's observation. It takes the control of that litigation out of the hands of the company. And that's paragraph 59 of Lord Reed's judgment in Merrick's. So those are the facts against which, in our submission, the question of whether the rule applies has to be determined. And in our submission, it's worth pointing out that it's not difficult to envisage that essential fact pattern occurring in other cases. So it's one that could easily reoccur in circumstances where an individual establishes a business which he then incorporates, taking shares in the company in return for the enterprise transferred to the company. If an advisor wrongly advises the individual and the company, and they're both claiming to have suffered loss, one before, one after transfer, the essential issue that confronts the board may arise in other cases. So, putting it at its lowest common denominator, the issue before the board is this. If P transfers an asset to the subject company, H, by way of a subscription payment for equivalent value of shares in H, and P and H allege that they have suffered loss in respect of that asset, P before transfer and H after, does company law and H's claim would make good that loss through restoration of share value? Does company law treat P's loss as separate and distinct, such that P can sue in competition with H? And we say the answer is no, and P's claim is barred. And we say that because the in specie transfer brings P into the normal shareholder relationship with the company. And Marix explains that it's because of that relationship that the shareholder has no rights to sue in respect of a loss suffered on the company's assets. And we say it makes no difference that the shareholder originally owned those assets before they were transferred by way of subscription payment. In our submission, all the reasons a shareholder's claim is barred in the normal scenario apply equally in the in specie scenario. And my lords, in effect, what Primeo is asking the court to do is to ignore and, in effect, unwind the in specie transfer in order to allow its claim against the respondents' claim to proceed in advance of Herald's claim. And the way they do that is really twofold. Firstly, they say the relevant reference point for the application of the rule is the date on which the loss was first suffered by Primeo. And so in consequence, they say, ignore whatever happened after that, so you don't need to take into account the Herald transfer, except by way of giving credit. We say that's wrong, because the reference point is when the claim is made. The other way in which they effectively ask you to ignore the effect of the Herald transfer is they're saying that the nature of the loss first suffered can't change. And so that will take us into the no change point. And we say that once you establish the relevant reference point as being when the claim is brought, you take account of the share transfer, which means that what used to be a separate and distinct loss ceases to be a separate and distinct loss. And that was the reasoning of the Court of Appeal below, which my learned friend only referred to once or twice, but particularly in relation to the no change point, we say the Court of Appeal's reasoning was absolutely correct. So, my lord, with that, can I then just explain very quickly the financial impact of the Herald transfer? And I hope this will answer the point my Lord Reed was making. We give the figures at paragraph 25 of our case, that's MS 847. But let me just give you the figures. You know that the Herald transfer valued the direct Bilmis investments at £485 million odd. And that valuation included the fictitious profits as reported by Bilmis. And it was on that basis that Primeo received equivalent value of shares in Herald. in fact, on a net cash in, cash out basis, those direct bonus investments were only worth 149 million. Now, distributions in Bilmis's bankruptcy under US bankruptcy law were made by reference to net investments, in other words, the cash basis, not by reference to the fictitious profits Madoff reported. So the consequence was that Herald could only prove in the bankruptcy of Bilmis for the net cash value of 149 million, not the price of 465 million paid to Primeo under the in-specie transfer by way of the issue of shares. And the resulting litigation between Primeo and Herald was essentially whether Primeo was entitled to prove in Herald's liquidation by reference to 465 million, the value of the issued shares, or only in relation to 149 million, which was their net cash value. Now, as I think it was Lord Kitchen observed this morning, Herald initially tried to void the in-specie subscription. It said that it was void for error. That failed, and the point that was ultimately resolved by the Privy Council is that Herald was bound by the valuation given on the in-specie transfer, and there was no rectification possible. So Primeo was left with a claim for 465 million into the Herald estate. And the consequence of that, as Mr. Justice Jones observed in his September 2016 judgment, we have it at MS 1520, but I don't need to ask you to turn it up, is that through the Herald transfer, Primeo became one of the major beneficiaries of the Madoff fraud, and that was done at the expense of the Herald shareholders. And that's because Primeo received the right to prove in the Herald liquidation for 465 million, or by reference to 465 million. But in return, Herald only received the right to prove for 149 million in the Bilmis bankruptcy. So in other words, Primeo will succeed in making recoveries in respect of the £316 million fictitious profits, which it can now claim by virtue of claiming under the in-specie transfer. So putting it at bottom line, most simplistic, if Primeo had not entered into the in-specie transfer, it would only have been able to prove in the Bilmis bankruptcy on a net cash basis, so that is for 149 million, but now it has a right of proof against Herald in respect of 469. And that, we would submit, is one of the obvious reasons why Primeo was wanting to enforce the in-specie transfer as against Herald. And since Marex is looking at the nature of the relationship between the shareholders in the context of what is an enterprise where all of the shareholders follow the fortunes, we submit that in good conscience, Primeo can't complain about Herald's claim taking preference in circumstances where those were the claims that Herald brings is in relation to the very assets that were transferred under the in-specie transfer. So, my lords, by way of introduction, that we say is the relevant background. In terms of what drives the difference on the timing issues, in our submission, they're really threefold. Firstly, the question of what I will describe as being the reference point. What is the reference point by which the court determines the applicability of the rule? Is it date of loss, as my learned friend suggests, or is it the date on which the claim is brought? And that, as I think we've all recognised, is the crux question. The second question is the question of capacity. In what capacity does the claim need to be brought? My learned friend says the claim has to be brought in the capacity of a shareholder, but he doesn't really spell out what that means with respect. What we say is that the requirement is that the claim is brought when the personal claimant is a shareholder, and it is a claim in respect of loss which would be made good by restoration of value to the claimant's shareholders. So that's the sort of capacity nature of loss issue. And then the third issue is the direct nature of loss issue, the no change issue. Can a loss cease to be separate and distinct for the purposes of the rule? So, my lords, just to put in the 5 or 6 propositions, if it's not entirely clear, what we say the position. First and probably foremost, we say the applicability of the rule is determined by reference to the factual circumstances existing at the time the claim is brought. That's the reference point. As regards the capacity issue and accepting the need for both parties to have claims against the same wrongdoer, we say that all that is required is that the claimant be a shareholder in the company at the time the claim is brought. As to the nature of the loss, we say that the essential requirement is that the shareholder's claim be for loss suffered through diminution in value of shares or distributions that would be made good if the company's claim against the common wrongdoer succeeded. And by virtue of the held transfer, we say that was the case here, because Primeo's loss would be made good. And in those circumstances, because it is the very assets in respect of which Primeo claims in Cayman that provided the basis of that transfer, we say Primeo cannot properly complain that Herald's claim bars Primeo's claim. So, my lords, with that, could I turn to the reference point, what I've described as being the reference point. The question of whether the rule applies by reference to when damage was first suffered or by reference to when the claim was brought. And, my lords, there are now 4 decisions on this point, and they have all concluded that the reference point is the time the claim is brought. So the 4 decisions are, first, Mr. Justice Jones' decision at first instance. So you can see his reasoning at MS 149 to 160, particularly at paragraph 289. Secondly, we have the Court of Appeal decision in this case, and there the reasoning is brought together at paragraph 415, which is MS 325, approving the approach of Mr. Justice Jones. Third, post-Marex, Lord Justice Flo in the Nectris decision, in particular at paragraphs 42 and 43, so that's MS 1093. And then fourthly, again post-Marex, Sir Nigel Tear's decision in Allianz and Barclays, which my learned friend took you to this morning, which is MS 1121 to 1124. And in the first case, Nectris, as you've seen, Lord Justice Flo held that the rule does not apply to a shareholder, to a claimant who has ceased to be a shareholder at the time the claim is brought. And the Allianz decision is in relation to a shareholder who had redeemed. And I'll come to Allianz, I'll come to both of those decisions later. Important to appreciate that in Nectris, Lord Justice Flo rejected the suggestion that the relevant time for assessing the application of the rule was when loss was first suffered. He applied a test by reference to the date the claim was brought. And equally so in Allianz. It's interesting to note that there, the loss was suffered by the shareholder while they were a shareholder through the increased FX fees. But the fact that they suffered that loss while they were a shareholder did not result in the rule applying. My Lords, in our submission, this reference point is clearly an important point for the practical application of the reflective loss rule, in the sense that judges are having to apply the reflective loss rule at the strikeout stage, and clarity in the law would certainly be enhanced by specification as to what is the point that the court is looking at for the purposes of applying the rule. So, my Lords, we say that there are 5 reasons which point quite clearly to the reference point being the point at which the claim is made. And my Lords, we summarise those at paragraphs 83 to 88 of our case, which your Lordships have at MS 862. And if I could just walk through those 5 points. And the first, we say that the Court of Appeal below was entirely correct to conclude at paragraph 415, so that's MS 326, that this necessarily followed from Lord Bingham's statement in Johnson that the object is to ascertain whether the loss would be made good if the company had enforced its claim, or to put it differently, or sorry, put the same point differently, whether the loss claimed is merely a reflection of the loss suffered by the company. Now, I accept that the specific sentence relied upon by the Court of Appeal from Lord Bingham's speech in Johnson was not specifically approved by the Supreme Court in Merricks. But what the Supreme Court in Merricks did do is to affirm, with explanations, Lord Bingham's 3 propositions. And Lord Bingham's proposition 1, which we see cited in Merricks at paragraph 41, which is MS 1019, makes exactly the same point. And so if I could ask you to turn to MS 1019, the first proposition, the second and third sentences, no action lies at the suit of a shareholder suing in that capacity and no other to make good a diminution in the value of the shareholder's shareholding, where that merely reflects the loss suffered by the company. A claim will not lie by a shareholder to make good a loss which would be made good if the company's assets were replenished through action against the party responsible for the loss. So, since that is the principle that underlies the rule, we say that the Court of Appeal was absolutely right to say that that focused attention on the position when the claim is brought, not when the cause of action accrues or loss is suffered. The second point we make, and this is the respondent's case at paragraph 85, is that the Court of Appeal was correct to conclude that looking at the position at the time the claim is made is consistent with according centrality to the type of loss, not the nature of the claim. And that reasoning remains equally sound post-Merricks. So, just to make that good, post-Merricks, the focus remains on the nature of the loss claimed, and that is confirmed by my Lord Reed at paragraph 47 of Merricks, MS 1021, where, as regards Lord Bingham's third proposition, my Lord Reed finishes that paragraph by saying the proposition makes it clear that the rule in Prudential renders certain heads of loss irrecoverable rather than barring a cause of action itself. The second point we would make in this context is that pre-Merricks authority made clear that the Prudential rule was not dependent or circumscribed by the nature of the personal claimant's cause of action. So in other words, it's not dependent upon the nature of the cause of action. And there is nothing in the Supreme Court's decision in Merricks to suggest that that has changed. And we see that in particular from paragraph 73 of my Lord Reed's judgment, where in the context of Gardner and Parker, the court records that the first question was whether the reflective loss principle applied where the wrongdoing took the form of a breach of fiduciary duty rather than breach of a duty arising out of common law. And as my Lord references, that aspect of the decision is not challenged. In other words, the reflective loss rule is not looking at the nature of the cause of action, it's looking at the nature of the loss suffered. The third point, which we make at paragraph 86 of our case, is, and in a sense this is coming to the crux of it, the post-Marex rationale of the rule also shows why the point of reference is the position when the claim is made, not when the cause of action accrues or loss is suffered. And conscious of the fact that I'm speaking to the authors of the book, as it were, Marex makes clear that the rule in Prudential is not a rule of damages, but a rule of company law. It's founded on the rule in Fossil Harbottle and exists to prevent that rule being subverted. And we suggest that the essence of the reasoning of the majority in Marex is found at paragraphs 31 to 38 in my Lord Reed speech, so that's MS 1016. And the essentials are summarized at paragraphs 80 to 83, which is MS 1030. And the reasoning proceeds in this way. At paragraph 31 and 80, so paragraph 31 is at 1016, the court emphasised that a share confers a right of participation, not a proportionate part of the company's assets. At paragraph 35, the court explains that the consequence of that is an acceptance of majority decision making, subject, of course, to the protection of derivative actions and the like, and that a shareholder follows the fortunes of the company. And at paragraph 37, the court explains that that is why the rule in Prudential has been said to recognise the unity of economic interests which bind a shareholder and his company. And then just picking up on Lord Hodges' speech at paragraph 108, he also sets out what he regards as being the most significant consequences of the characteristics of a shareholding as a means of participation. And in our submission, it's because of the relationship established by that shareholding that considerations of company autonomy, protection of creditors, and equality between shareholders requires the personal claim for loss suffered through diminution of value of shares and dividends to be denied. Now, in our submission, all of those considerations which one sees founding the rule in Marex operate by reference to the position at the time the claim is made, not when the loss is suffered. So the mere accrual of a cause of action or loss does not impinge on majority decision making, nor does it impact on company autonomy. In contrast, it's only when the claim is actually made that questions arise as to majority decision making and or company autonomy. And we would suggest it is only if the unity of economic interests arising from a shareholding exists at that point that there is a justifiable rationale for deeming the personal shareholder not to have suffered a loss. And in actual fact, we would suggest that the question makes no sense unless you ask it at the time the claim is being brought. can I put the same point in more concrete terms, in one sense? A person who is a shareholder at the time he brings his competing claim, he stands to benefit if the company's claim succeeds through restoration of value to his shareholding. He has, at the time he brings the claim, the right to participate in majority decision-making regarding the conduct of that claim. He has potential remedies, such as the derivative action or unfair prejudice applications, in the event of legitimate dissatisfaction with the conduct of the company's claim. In other words, all the safeguards, which are the corollary of the barring of the shareholder's claim, they all operate by reference to the time the claim is made. And my lords, maybe the essence of the point can be made even more simply. And this was the point that was made in Nectarus, paragraph 50, and we have that at MS 1096. And here the court was considering the reverse situation. The question of whether the rule in prudential bars a claim by a shareholder, by a claimant who has ceased to be a shareholder at the time the claim is brought. And at paragraph 50, the point was made that the rule in Foss and Harbottle does not apply to an ex-shareholder, so that there would be no justification for applying the rule in prudential, which is designed to prevent the Foss and Harbottle rule being subverted. There would be no justification for applying that rule to a person who is an ex-shareholder. And we submit that logic, though simple, is compelling. If, putting it in this way, if the rule in prudential is a refinement or a derivative from the rule in Foss and Harbottle, and the rule in Foss and Harbottle wouldn't apply to an ex-shareholder, the rule in prudential can't apply. And that's why Lord Justice Flo was of the very clear opinion that it was beyond doubt that the Supreme Court in Marex had decided that the rule does not apply to an ex-shareholder. And in our submission, the logic of that analysis must also operate in the reverse situation. Even if the claimant was not a shareholder at the time the claim accrued or loss was first suffered, if he becomes one by the time the claim is brought, the rule in Foss and Harbottle is capable of applying to him. And that's because by becoming a shareholder, he has acceded to majority decision-making and the requirements of company autonomy. He, to put it colloquially, he's become a member of that follow the fortunes enterprise. So just as the rule in Foss and Harbottle is binding on such a shareholder, so too is the rule in prudential, which is designed to prevent the rule in Foss and Harbottle being being subverted. It's the rule in Prudential is fundamentally founded on the relationship between shareholders and the fact that they are members of the same follow the fortunes enterprise. And in that context, we suggest it's useful to look at Lord Hodges' speech at paragraphs 102 to 108 in Merrick's. So that's at page 847. I'm sorry, it's MS 1035 to 1037. And Lord Hodge, in those paragraphs, so page MS 1035 to 1037, paragraphs 102 to 108, Lord Hodge makes the point that investing in or conducting business through a limited liability company carries advantages and disadvantages. And one very obvious advantage is limited liability. So that's paragraph 102. A disadvantage may be said to be submission to majority decision making and the application of the rule in Prudential. That's paragraph 107. And if I can ask your lordships to look at paragraph 24 of our case, which is at MS 847. We set out there the judge's findings as to why Primeo decided to enter into the Herald transfer. And Primeo, or UniCredit, the investment advisor, decided to do so, at least in part, because it wanted to invest through a corporate entity that provided a clear barrier of limited liability. So Primeo was investing in Herald because it wanted to take advantage of that corporate benefit. And the judge, later in that same paragraph, at paragraph 271, MS 144, concluded that it suggested a desire on the part of the investment advisor to distance itself from responsibility for monitoring a managed account at Bilness. So in our submission, having taken that corporate benefit and asserted its shareholder rights against Herald by asserting the right to prove in the Herald liquidation for 475 million, not just the net cash value of 149 million. In our submission, Primeo cannot properly complain that it's subject to the concomitant disadvantage of the rule in Prudential. So, my lord, that's the third point, that if one is looking at the Merrick's rationale, we say that that points very, very clearly to the reference point being when the claim is brought. The fourth point that we make at paragraph 87 of our case, which is MS 863, is going back to paragraphs 42 and 43 of Lord Justice Flo's decision in Nectris. And there, as I've already mentioned, Lord Justice Flo recorded that he agreed with the decision of the Court of Appeal in this case, but went on to say that in any view he thought it was right in principle And maybe I could just take you back to paragraphs 42 and 43, which we have at MS 1094. And there, the learned Lord Justice said that he thought it right in principle that the applicability of the reflective loss rule be determined when the claim is made at a time when the loss claimed has crystallized, and not some earlier date when, although there may have been a breach of contract, the loss claimed had yet to crystallize. And I said that Lord Justice Flow had specifically rejected the suggestion that the rule should be applied by reference to when loss was suffered. And in our submission, that's made good by looking back at paragraph 40 to see what Mr. Butler, so that was Nectris's counsel, who was submitting the rule should bar the claim, was arguing. And what he was arguing, and taking it very quickly, is that the cause of action arose when Nectris breached the IMA and what became known as the stranded deposits were invested in the Indian companies. So that investment was made under a 2006 management agreement. And the point, the investments weren't made until I think about 2011. But the point that was being made was that loss was first suffered when these monies were remitted to companies that ended up being sham entities. And so what Mr. Butler was saying is, cause of action arose when these people were shareholders. They first suffered loss when these people were there still shareholders. Therefore, their claim is barred by the rule. And that's the point that Lord Justice Flow is rejecting at paragraph 43, when he was indicating that the application of the rule has to be determined at the time the claim is brought, when where the loss has crystallized. So, my lord, that's what we say about Nectris. My learned friend goes so far as to say that Lord Justice Flow's decision in Nectris was wrong in concluding that the rule did not apply to ex-shareholders. I submitted why the decision in our submission is obviously right, and so I won't repeat those points. My lords, my learned friend also referred to the Appellant decision. That's the decision we have at MS 1100. There, it's significant to note that the loss was suffered when the investors in the fund were still shareholders, because the FX charges would have reduced the value of their investment. But I agree with what my learned friend was submitting, that in one sense the real rationale of Sir Nigel Tier's decision is that the loss had been passed on because the shares had been redeemed. So Nectris was a sale of shares case, Allianz was a redemption of shares, and I would not disagree with my learned friend that the nub of Sir Nigel Tear's decision was not centrally on the timing point, but the fact that the loss had been passed on. My Lord, the fifth and final point that we make in relation to this is the point that we make at paragraph 88 of our case. And that we have at MS 863. And the point that we make there is that applying the test by reference to the factual circumstances existing when the claim is brought is consistent with the concern for pragmatism underpinning the rule. And my Lord Reid at paragraph 38 of his speech in Merrick's, that's MS 1018, emphasised the pragmatic advantages of a bright line rule. And in our submission, those pragmatic advantages would be promoted by a rule which establishes that the applicability of the rule is determined by looking at the facts and circumstances existing when the claim is made by reference to the loss crystallized. But as I say, it's not just a pragmatic advantage. It's an approach which is founded on the premise that underlies the Merrick's decision. Foss and Harbottle only applies to a person who is a shareholder. The questions that you are asking oneself under the rule in Prudential really only make sense if you ask those questions in the context of the facts existing at the time the claim is made, because it's the claim that competes with the company's claim. And just focusing back on paragraph 59 of my Lord Reid's speech in Prudential, in Merrick's. So that's page 1024. And this was talking about Lord Millet's second policy consideration, but which in this instance my Lord Reid agrees with. The second policy consideration was that it would be difficult for a liquidator to settle claims against wrongdoers for the benefit of the company's creditor if the wrongdoers remained exposed to further claims by the shareholders. The conduct of the company's claim would effectively be taken out of the liquidator's hand. The point is addressed by the rule in Prudential, consistently with the underlying rule in Foss and Harbottle. To achieve that rationale, you clearly need to look at the time the claim is brought. My Lord, those were my submissions on what I've called the reference point. If I could now move on to the capacity issue, and then we'll move on to the nature of the loss issue. Your Lordships have the parties' written submissions, and our submissions are at paragraphs 72 to 74 and 89 to 98 of our case. My Lord, if I could ask your Lordships to turn that up at MS 860. And at paragraphs 78 and 79, we accept that the first limb of the Court of Appeal's reasoning on the capacity point is no longer good law, because that was based very much on Lord Millet's extension to the rule to creditors. So we accept that is no longer good reasoning. However, as I've just submitted, the application of the rule has to be assessed by reference to the factual circumstances existing when the claim was brought. That was the approach that the Court of Appeal took. And at that point in time, Primeo had transferred the Blinus assets, the subject of its claim in Cayman, to Herald, in return for an equivalent shareholding in Herald. So at that time, the relevant time, Primeo was a shareholder in Herald. Further, as a result of the loss claimed by Herald in Luxembourg, Primeo's claim in Cayman would be made good through restoration in value, and therefore, in our submission, the requirement of being a shareholder at the time the claim was made was satisfied. My lords, could I just deal with one point quickly that features prominently in my learned friend's written case, but not so prominently in his oral submission. But I don't think it's been abandoned. And one sees at paragraph 6 of Primeo's case, which is MS 797. But the point they make is that they say Primeo's claims are not claims which accrued to Primeo in its capacity as a shareholder. So there they seem to be looking at the capacity in which the cause of action accrued. And then at paragraph 19 of their case, which we have at MS 803, they try and say, in distinctions of that, Primeo's claims were being made as contractual counterparties, as if in consequence that meant that the rule could not apply. And we also see that at paragraphs 55 to 58 of Primeo's case. And so, for example, at paragraph 56, ultimately the Court of Appeal's approach is wrong for failing to take into account and accept all the reasons explained by the Supreme Court in Merrick's as to why the reflective loss principle is confined to claims brought by the plaintiff in its capacity as a shareholder. So what my learned friends seem to be saying there was that it was necessary for the claim to be brought in the capacity as a shareholder. Now, if and insofar as they were trying to suggest that that means that the rule only applies where the cause of action accrues by virtue of the claimant's status as a shareholder, we say that's wrong. To put it another way, the duty that founds the personal claim need not be one that is owed by virtue of being a shareholder. And I'll take that quickly, but we say that's self-evident, because if you look, for example, at Johnson and Gore Wood, the personal shareholder was suing on the basis of the breach of the solicitor's retainer to him. That was the nature of his claim. And that duty wasn't owed to him in his capacity as shareholder. It arose because of the engagement between them. And I make the point because in my learned friend's case, there are aspects where he's trying to suggest that the rule is confined to circumstances where the cause of action accrued to you in your capacity as a shareholder. And that's clearly not right, as shown by the case of Johnson. And so the mere fact that my learned friend asserts that the claim was under a contract with R1 or R2 does not preclude the operation of the rule. So with that by way of introduction, can I just ask the court to look at what Marex actually says in relation to the shareholder capacity. And could I ask your lordships to go to paragraph 79 in Marex. It's necessary to distinguish between cases where claims are brought by a shareholder in respect of loss which he has suffered in that capacity, in the form of diminution in share value or in distribution. Now, in our submission, the phraseology in that capacity qualifies how the loss is suffered, not the capacity in which the claim is brought. So the first part of the sentence, where claims are brought by a shareholder, is unqualified. So the claim does not have to be one which is brought qua shareholder, in the sense of in respect of a duty owed qua shareholder. That's shown by Johnson itself. So the capacity qualification relates to the loss suffered, not the claim. It's the loss which must be suffered in the capacity of shareholder. In other words, as Lord Reed continues, as is spelt out, in the form of diminution in share value or in distribution. So the capacity point actually relates to the nature of the loss, not the capacity in which the claim is brought. So in terms of the capacity requirement or the threshold requirement, it's a very simple requirement. It's simply, are you a shareholder at the time the claim is brought? The second question is then, what is the nature of the loss in respect of which you claim? So, my lords, taking it quickly, it's for that reason that we say that my learned friend's arguments at paragraphs 55 to 58 of his case in relation to capacity, which we have at MS 823, are misapplying or misunderstanding what Marex is saying. As we see at paragraph 55, Primeo wrongly asserts that prudential cannot apply unless the claim is being made by the plaintiff in the capacity of a shareholder. Well, we say that that's not correct. The fact that the fact that the true test is actually the capacity in which the loss is suffered is actually more accurately reflected at paragraph 41 of my learned friend's case, which we have at page MS 815, where my learned friend's case says, it follows that what is critical is the capacity in which the shareholder has suffered loss. And that's correct. That is what paragraph 79 is saying. The capacity point qualifies how the loss has been suffered, not the capacity which the claim is brought. So, my lords, just on this capacity point then, in our submission, the two key capacity and nature of loss requirements established by Marex regarding the application of the rule are simple and straightforward. First, was the personal claimant a shareholder in the relevant company when the claim was brought? So in that case, that's looking at the position in 2013, not pre-May 2007, when the loss was first suffered. Second, is the claim for loss suffered through a diminution in value of shares or dividends, which would be made good if the company's claim against the common wrongdoer succeeded. And that, again, falls to be answered by reference to the facts and circumstances existing when the claim is made, that is in 2013. My lords, I was then going to move on to the no change point, which in our submission is the second critical issue, and it may be more convenient if I make those submissions starting tomorrow morning.
We'll agree now.
My lord, I'm sorry, I can't.
Oh, I'm sorry. I'll move this microphone closer to myself. Very well then, we'll adjourn now and resume at 10:30 tomorrow morning. Thank you all very much.
Thank you.